Πάμε άμεσα στο επόμενο πάνελ και απολογούμε πάρα πολύ για την καθυστέρηση και στους ομιλητές και στους θεατές. Το επόμενο πάνελ έχει ως θέμα την εισήγηση για εισαγωγή ενός τρίτου καναλιού διαχείρισης υποθέσεων για τις μικρές απαιτήσεις, αλλά και τη χρήση εναλλακτικών μεθόδων επίλυσης διαφορών. Ο συντονιστής είναι ο συνάδελφος Άγης Γεωργιάδης και στο πάνελ συμμετέχουν ο Μάρκο Τζακαλώνε, η Ελένη Τζουνάκου, η Νέβη Αγαπίου, ο Χαρίς Δημητρίου και η Θεανό Μαυρούμουστάκη.
Well, congratulations for to the organizers and thank you all for your patience to remain with us on a Saturday until so late. So why are we discussing small claims is something that we need to start with, I believe, because small claims is not a term used for insignificant claims. Small claims are important. They're important because they're important for the people that bring them to court. What is small for some may be huge for others. It is important for us as lawyers and the judicial system because they take probably the majority of resources. And it is also important as a social phenomenon because the access to justice should not be a privilege to the wealthy. Access to justice should be free and accessible to all. And by accessible, that also includes affordable. In Cyprus, there was an attempt to introduce a small claims track in 2014 for claims up to 3,000 euros, which was put in application in parallel with the EU Small Claims Procedure Regulation, that's 861 of 07, for those who want to keep a record. But it appears that both were ineffective for various reasons that time doesn't allow me to discuss right now, but they didn't really seem to produce the desired result. And this has actually has probably led to the accumulation of backlog in Cyprus. Now, with a new CPR, we have Part 29, which deals for the small claims track for claims up to 10,000 euros. I would expect that this different approach of the CPR with the overriding objective and litigation as seen as a last resort, including the positive duty of litigants to exhaust other steps before they actually take a case to court, may assist in getting rid of the backlog and to providing a more accessible justice for small claims. And at the same time, the proposals for ADR, which will be discussed later on, hopefully will assist in that purpose. Now, I'm very happy to be moderating a very distinguished panel here. We have on my direct left, and that's not a political position, we have Professor Marco Giacalone, a research professor at the Private and Economic Law Department, co-director of the research group on digitalization and access to justice of the Vrije Universiteit Brussels. He has been involved in several collaborative research projects funded by the EU. His work analyzes the transformations of law in the field of access to justice with a special focus in the fields of private international law, ADR, ODR, EU regulations, and the application of economic principles into the field of law. His research combines approaches from legal theory, empirical legal studies, and science and technology studies. He is a holder of a PhD from BUB and Naples University with a thesis on dispute resolution and new IT realities. On the far left, again, this is not a political position, we have Eleni Tsunakou. Eleni is a judge of first instance in Corinth, Greece, previously an advocate, member of the Athens Bar Association. She has authored the book on European Account Preservation Order under Regulation 655 of 2014, as applied in Greece, issued by Sakulas in 2021, and also made several contributions in joint works and conferences in relation to civil procedure and ADR. On the far right, Dr. Nevi Agabiou, lecturer in international commercial law and dispute resolution at UCLan. She has a PhD, an LLM, and an LLB, all from Leicester University, so she must have enjoyed her time there. So she's also an accredited mediator and an advocate of the Cyprus Bar Association. Her main research interests include international commercial law, ADR, comparative law, civil procedure and legal reform in Cyprus, and legal design, which I hope she will explain later on. In the second position to the right is Theano Mavromoustagou. I could talk about Theano for days, all positive things to say about her. Theano is a scientific collaborator at EUC and the University of Cyprus, a holder of LLB and an LLM from Reading University, an attorney of the Republic, head of civil division. She represents the Republic in numerous organizations and fora, has regular contributions to conferences and legal training. I'm very honored to be a member with her in the Rules Committee of the Supreme Court, and she's the contact point of Cyprus to the European Judicial Network on Civil and Commercial Matters, and chairperson of scientific committees of the Council of Europe and others. And on my direct right, Haris Dimitriou. Haris is a colleague, a managing partner at Haris D. Dimitriou & Co. LLC, specializes in civil and commercial litigation, arbitration, commercial, and corporate law. He has extensive experience in complex litigation with a multi-jurisdictional element involving multi-million claims before the courts of Cyprus. He handles a portfolio of corporate clients and high net worth individuals and regularly advises corporate clients, including investment firms, fund managers, and funds. He's an arbitrator. He's a CIR member, an ICCA member, and an accredited mediator. He is currently a member of the Judicial Council and a member of the CAMC, the Cyprus Mediation Arbitration Center. Starting with Marco. Marco, could you please tell us a few words about the EU legal framework for small disputes?
Yes. Thank you, Agis, for your introduction, and thank you also, Nicholas, for the invitation. Just to have also an understanding of what do you know about the current regulation, may I ask also to the public to raise your hand if you heard or if you read by any chance the new regulation of digitalization in judicial cooperation and access to justice that was published last year, actually, or more or less exactly 1 year ago, on December 2023. I have 2 hands, some words?
3,
okay.
4.
Okay. So, just to have an understanding, yes, so mainly, I think, to answer your question, I will refer to this document that, as you may know, or for all the people that they don't know, it's a transversal regulation, an umbrella regulation, so it's not focusing only on small claims, but it touches a lot of regulation and directive, and of course there is a section explicitly on small claims. For example, as another example, the UAI Act, also this regulation is not entering into force only in one date, but it has different steps. So, for example, related to small claims, it will enter into force in January 2026. And, okay, now let's go into the content. What this regulation is talking about that has entered into force in 2026, so 1 year and 15 days. Mainly, the main principle that you can see all over this regulation is the digital by design. As you may know, in a lot of legislation, we're not speaking only about Cyprus or just one state, digital by design, so digital as the rule and not as the exception, is not happening in any of the current member states. So that's the change that from above is trying to push all the member states to try to use digital by default. And in how? For example, first of all, that all the documentation has to be handled electronically. As you may know, still, for all the lawyers that we have here, all the judges, in several member states, everything still happens manually, paper-based. Also, pushing a lot for the application of tools like video conferencing, and especially also things that look small or tiny, but they're not, like, for example, the possibility of using e-signatures online, and payment of the fees to start the small claims, everything online, everything digital. And then, of course, there are the efforts to try to have an harmonization, because as you may know, like for example, for the expert of the procedure, small claims has a limit. So we're speaking about, for the European dimension, 5,000 euro as a maximum. So all the claims that has to be under this amount, and with the one important aspect, the cross-border aspect. So it has to be between 2 or more member states. The point is that through also this legislation, we discuss also about the difficulties that we may have because of the understanding of what is a small claim. Since in every legislation, we have a different understanding, we have a different value. Just to give you an understanding, we go from 600 euro in Germany until 25,000 in the Netherlands. So, in European level, we have 5,000. But at national level, we start from 600 till 25,000. So it's a different conception that in every single member state we have, and a different use. So now, try to go all together towards one direction, towards one also IT main central decentralized point, that for the EU is the e-justice portal. It will commit a lot of efforts in order to get to this point.
So, okay, what you're describing a complete framework for this type of disputes? What can be done to improve it?
Yeah, so of course, thanks for the question. The framework is not complete yet because, for example, I was in April, the European Judicial Network meeting, and one of the main questions that from the Commission was posed to all the member states was regarding about this limit. How actual can be right now at European level this amount, maximum amount of 5,000 euro, and if it's worthy to raise it. So another important connotation of this small claim procedure is that there is not mandatory the presence of a lawyer. And I think it's here also that there is the issue of raising or not this amount. Because if we want to raise the amount, but keep the fact that you can also access these disputes without a lawyer, we need to take into account all national civil procedure regarding the fact of being self-represented when you have like a specific amount of money.
Well, I think that's exactly why the European regulation could not work in Cyprus so far, because it basically prescribed a procedure which was documents only, but nobody could actually do that without a lawyer. And even when they did, they had to face all this bureaucracy from the civil registries, which they couldn't overcome.
Yeah.
So if I can turn to Nevi now. Nevi, your research is comparative. You're largely focusing on England and Wales and Cyprus. How does the English system deal with small claims?
So before I address the specific question, just to discuss why we should be monitoring the English civil procedure rules. I think one of the first answers is obvious, is that we have historic links between the two legal systems. Cyprus was once a British colony, but also on the basis of comparative theory, we have had a recent legal transplantation process. This is what happened, which led us to the acquisition of the new CPR rules. And if I may just quote what was stated, that all stakeholders agreed that the best starting point for any review would be the existing civil procedure rules for England and Wales, and that these rules should be adapted to take account of Cypriot practice, culture, and custom. So there remains a great value in monitoring what is happening in England and Wales. We have to remain aligned with best practices in anticipation of future challenges, but also identify potential pitfalls. We also need to build in Cyprus and allow for institutional knowledge for both lawyers, judges, and the judiciary, the judicial system as a whole. We have to also be careful that we avoid legal obsolescence, in the sense that we don't allow the CPR rules to remain stagnant, but we are progressing them. Now, in relation to the small claims track and what's happening in England and Wales, Obviously, the model we adopted here was what they have over there. So the small claims track is the normal track for any claim which has a value of not more than £10,000, subject to special provisions about claims for personal injuries and housing disrepair claims, supported by a strong online court environment. And I have to stress that the support that they have in terms of the online environment is key. Typical claims would be consumer disputes, accident claims, disputes about the ownership of goods, and most tenancy disputes. But for example, a case involving a disputed allegation of dishonesty usually will not be suitable for the small claims track. Now, in Practice Direction 26, we get some guidance that this is a proportionate procedure without substantial pre-hearing preparation and traditional trial formalities, without incurring large legal costs. It's possible for a litigant to conduct their own case without legal representation if they wish, and the court would not normally allow more than 1 day for the hearing. We have taken inspiration from this, so we also have these requirements. But before a new addition and a pilot scheme, I'd like to touch on the costs for the small claims track, which is always a concern. So the small claims track in England and Wales minimizes costs by limiting recoverable legal expenses and capping other recoverable costs like expert fees and loss of earnings. Now, this ensures accessibility and keeps the process straightforward for self-represented parties. Generally, the court fees in the small claims track are lower than those on the fast track or the multi-track. And indicatively, as I don't have the time to go into the whole scheme of how it works, the amount of fixed commencement costs in a claim for the recovery of money or goods range from £50 to £110, which I think is rather accessible for the small claims window that we're talking about. Hearing fees charged for all cases are also calculated on a sliding scale depending on the value of the claim. Now, in relation to the guidance that we have on how small claims are approached, what we had before the English CPR rules, so we had Order 19 of the County Court Rules 1981, which covered the automatic reference of small claims to arbitration. The arbitration procedure was a normal method of resolving small, relatively simple claims under £3,000 or £1,000 in the case of personal injury, and claims were automatically transferred, i.e. referred to arbitration when a defense was filed. Now, when the CPR was enacted and the English CPR came into force on the 26th of April, 1999, the small claims track was introduced for claims under £5,000 initially, or £1,000 for personal injury and certain housing disrepair claims. Due to the perceived success of the small claims track, the 60th update to the CPR, which came into effect in April 2013, doubled the qualifying limit of small claims to £10,000, which is what we currently have. Now, my position is that an effective small claims track, no matter how effective, how robust it may be, both in relation to speed and costs, is not enough to ensure access to justice, and that court resources are used efficiently, as well as avoiding judicial delays threatening the rule of law. Now, there is a mediation pilot scheme that is currently running in relation to which affects small claims. Now, this is Practice Direction 51ZE, Small Claims Track Automatic Referral to Mediation Pilot Scheme. This practice direction provides for a pilot scheme under which claims to which the pilot applies are to be referred automatically for mediation, provided by the Mediation Service, which is operated by His Majesty Courts and the Tribunals Service. Now, the pilot is to run, and it's been running from the 22nd of May, 2024, and it will be running until the 21st of May, 2026, and applies to claims issued on or after the 22nd of May, 2024. Now, this applies where the only remedy claimed is, or purports to be, a judgment for a specified sum of money, and does not in any event apply to road traffic accident or personal injury claims. I also want to make reference to a leading case, James Churchill and Mirfield Titfield County Borough Council, a 2023 revolutionary judgment. So in this case, James Churchill made a claim against his Welsh local authority after discovering Japanese knotweed in his garden, I don't know if you know what Japanese knot weight is, but it's something that you must definitely not have in your garden in England and Wales. The Council argued that Mr. Churchill should have explored non-court dispute resolution options, such as its internal complaints process, before taking legal action. Now, the key question was whether a claimant unreasonably refusing non-court dispute resolution can be blocked from making a civil claim in court. The Court of Appeal reconsidered the long-standing precedent of Halsey and Milton Keynes' General NHS Trust, a 2004 case, which had established that parties could not be forced to engage in mediation. Now, the Court of Appeal deemed these remarks obiter and no longer reflective of the current law. So what happened as a result of Churchill is that Churchill was able to enrich the overriding objective of the English CPR rules with an explicit ADR reference. So Churchill, in essence, decided that it was lawful for a court to stay proceedings for or order the parties to engage in a non-court-based dispute resolution process, which resulted in the very recent, late October 2024 reform of the CPR in the form of an addition of an explicit reference to ADR in the English CPR rules. So this is now paragraph F, promoting or using alternative dispute resolution in order to enable the court to deal with cases justly and at a proportionate cost. Now, the ultimate goal, and I was glad to hear that this was being mentioned all day today, is what I would start from sustainable justice being human-centric justice. Now, the definition of sustainable justice, for those who are hearing the term for the first time, or low sustainability, is a very current issue of discussion. So sustainable justice is the approach to justice that aims to improve social harmony, well-being, the general feeling of safety within society, and furthers personal and societal development within a framework of human rights and principles securing legal uniformity and equality. In order to enable the justice system to intervene effectively, justice is vested with power and independence and acts in the pursuit of social sustainability of society and its members. This is a definition from the Center for Sustainable Justice, from their Sustainable Justice Charter. But ultimately, what we need to be aiming for by looking at procedures, small claims, on the small claims track, but also how do we embrace and use ADR, is ultimately towards achieving sustainable justice, which I think would also work in the favor of improving the public's opinion of justice.
But we don't have much time, but can you give us a brief comment about how you see the new CPR provisions on small claims in Cyprus?
It's largely, I mean, we've largely mirrored what is happening with in the English CPR rules, not in relation to costs though, which remains an issue because we have a very different approach to how we deal with costs, and I think that will probably be a problem. But the problem is that there is a mentioning of ADR in the civil procedure rules, but I don't think that is strong enough. So unless we allow our CPR rules to evolve as the English CPR rules are evolving and take inspiration from the expansion and enriching of the overriding objective, which is, it's absolutely the same if you compare it. It's the same. So
well, I believe Theano will have something to say about that later on. But I will now turn to Eleni. So Greece has developed new procedures for small claims. Could you tell us a few words about them, how they work?
First of all, I would like to thank the University of Nicosia and Nicholas Fodokiakidis for the invitation. In 2021, the Greek Code of Civil Procedure was amended, introducing significant changes to the small claims procedure. These changes included the adoption of standardized documents and digital tools to facilitate the procedure. This has not yet implemented, but it's very crucial to have this provision in our legislation. Also, the new law specified that if the plaintiff does not appear in court, the action will typically be dismissed. Conversely, if the defendant fails to appear in court, their absence is interpreted as an admission of the plaintiff's claims, leading to a favorable judgment for the plaintiff. This provision, previously limited to ordinary proceedings, now was applied for the first time to the small claims cases in 2021.
So the peace courts, Ειρηνοδικείο, was abolished.
Was abolished, yes.
Yes. Was that a good idea?
Historically, peace courts handled claims up to 20,000 euros, while cases exceeding this amount of money fell under the jurisdiction of courts of first instance. However, in September 2024, peace courts were abolished as part of a broader judicial reform in Greece. Now, all civil, commercial, and criminal cases are heard at first instance for the courts of first instance. The abolishment of peace courts has been always a contentious issue, debated publicly for years. Despite previous unsuccessful reform attempts, this change materialized in 2024. Official estimates suggest that eliminating peace courts could on its own accelerate the administration of justice by 17 to 25%. It's very early to say, but although there were some challenges in the first months of the application, now the challenges are gradually being addressed, and early results indicate positive outcomes by now.
Okay. Now, tell us about mandatory mediation in Greece and how it works. And did it manage to keep at least some cases out of the court system?
It's a big issue in Greece. The incorporation of a directive on mediation into Greek law in 2010 did not mandate mediation, and the system was unsuccessful in practice. Subsequently, law of 2018 introduced mandatory mediation in some cases. However, the Supreme Court ruled by majority that these provisions were unconstitutional and violated the European Convention on Human Rights. Then the court cited that the court cited the high financial cost of mediation, estimated at about at a minimum of 2,000 euros for the claimant as a barrier to justice. Moreover, the requirement of mandatory legal representation during mediation disproportionately affected the financially weaker parties, forcing them to accept mediation solutions rather than pursue court proceedings. Currently, law of 2019 governs mediation. It requires an initial mandatory meeting in some cases, such as specific family cases and cases exceeding 30,000 euros, heard in ordinary proceedings. During this meeting, the mediator tries to inform the parties about this procedure and its potential to resolve their dispute. This step is mandatory for any subsequent court action to proceed to a hearing.
Okay. There are thoughts about introducing mandatory mediation in Cyprus. Any thoughts on that, as we can get some inside information from you?
Yes. Before answering your question, I would also like to thank the University of Nicosia, and Nicola specifically for this invitation. And I would like to make some introductory comments before going to your questions. You started, wondering how important are small claims, and I will give you some numbers so you can understand. I'm head of civil section of the law office of the government, and the last 2 years we've been going through a huge reform. And last week we had some numbers represented, so we could understand where we started and where we are now. And I must tell you that small claims, defined as claims under 50,000 for the purposes of the presentation against the government, active cases, court cases, against the government were about 6,000. and larger claims against the government active in court were around 600. So that's how important are small claims if you consider how many people you need to handle them and how many judges to hear those cases.
More than 90%.
Yes. So they are important, and yes, we have to find ways to hear them more effectively. I will definitely disagree with you on why the small claims procedure in the previous rules, Order 35, if it was successful or not. My experience in my office from my colleagues who actually used that procedure, we had decisions in 9 months, which is unheard of for other kinds of cases. So I believe if we actually took advantage of that procedure, we could have had better results. Now, mandatory mediation. We do have some provisions in the new CPR rules, and we don't have a sample yet as how they could actually promote ADR. But the government is today, yes, promoting a new law, introducing mandatory mediation on small claims, namely claims under 10,000 euro. It's still under discussion, the reason being that it's mandatory. You cannot go to court if you don't go through this first meeting, and you have to pay. So, and no legal aid is offered in any way. So we did think if this was unconstitutional, and we have been studying Churchill and Darius Pagos' recent decision on that. So, yes, for some people, 150 euro, which was the original proposal for a mandatory first meeting before going to court, could be a hurdle in promoting their rights. It's still being discussed, and now our proposal was that this amount, if we cannot offer legal aid in the cases that legal aid would be offered if someone went to court, then this amount should definitely be diminished. And that's what we're discussing now. It's still being discussed between the Ministry of Justice and the Law Office of the Republic, and we're trying to find a way to make this simple. Again, we're coming to the mentality issues, that we have to understand that we're not going through this procedure to be able to go to court. We're going through this procedure because this could be the way to resolve our claims and not and avoid court procedures. So, but that's not something to discuss now. There is proposed legislation. We don't have a final bill to go to Parliament yet. And I must say that we're trying to exclude claims against the government.
Why is that?
Well, the Law Office of the Republic has set up a procedure. I should be proud to announce this, but I'm not really, because this should have been set up ages ago, but now it's ready, whereby people can file their claims under 10,000, and two of my colleagues will have a look at them and discuss them and actually try to find a solution. Having seen those numbers, you can understand why. And we're discussing claims under 10. So there will be a platform, it will be announced very soon, where people having a claim against the government can file this claim under 10,000, and they can have an immediate answer on whether their claim is accepted or not. We have already set up a procedure where all governmental departments are sending us details on any event, even if we don't have a claim, so we're ready to reply to people. So if this procedure is used properly and becomes known to people, maybe part of the 6,000 cases I referred to before could be diminished in minimum numbers.
It's not mediation, it's like a
sort of mediation.
Complaint, it's okay.
A complaints department, because is it really mediation if I'm the other party and we're discussing, so no mediator in that procedure. But then again, the other party is the state, and I think we should be able to resolve these issues not like opponents in a court, but like colleagues.
Okay, we look forward to see how that works. Harry, what about the Cyprus Bar Association? What does it do to promote ADR, and why? Why is it doing it, if anything?
Before going to that, just a small remark on the mandatory mediation issue, which is an internationally big dispute, whether it should be mandatory or not. So I belong to those saying that it cannot be mandatory, and it cannot be mandatory because it contradicts the whole nature of mediation as a process. Mediation is a process that brings two parties together because they want to get together and find a solution on their own. And if you find a solution with the other party that you like, then you are both happy. And from my life experience, you cannot oblige someone to be happy. So this is my understanding of that. I also can understand the fact that by mandating mediation, maybe we could create eventually some culture, some ADR culture that we lack. And this is something that we all agree, all the stakeholders agree, that we lack ADR culture in Cyprus. And I'm getting on to your question, what we do. I mean, us as CAMC, what we are trying to create here is culture.
Maybe you should explain what the relationship between CAMC and the Bar Association
is. The
is.
CAMC started some years ago as a private initiative, but it was eventually transferred under Cyprus Bar Association, and it's basically is the Cyprus Arbitration and Mediation Center, which provides assistance and support to arbitration proceedings or mediation proceedings. It has his own record of arbitrators and mediators, its own rules, and also, apart from providing those services to third parties, it promotes ADR in Cyprus. Going back to our discussion about the small claims, we have identified the problem, and this problem, I believe, it will be much more serious in the future, because I'm not sure whether claims of under 3,000 or 5,000 would be make any sense in getting them before the court. I mean, if you have a 3,000 claim and you have around 7 to 10% of it, of the main claim to pay as an actual expenses, what you're going to pay to a lawyer and what you're going to pay to in case you lose. I mean, it doesn't make any sense. So we need to give an alternative to that. We are for the small claims track, which should provide the opportunity for a person to just go on himself to a court, submit the form, wait for the judgment, but at the same time, we are for mediating the small claims. On that respect, we have designed a project which it was presented to the Supreme Court and we get the approval and their support in implementing it. So we are planning of getting it started on May, and it's mediation month. In 1 month, a CMC will assist without any cost to the parties, and we facilitate any mediation that concerns a case that is already before the court, but for any reason it will be adjourned or rescheduled to another date on May. So, and we are aiming for the small claims for under 10 or under 5,000 euros.
So it will be this year?
Yes, this year, 2025.
Okay.
In all district courts, CMC will provide the facilities, any administrative support if required, and from our registry of mediators, the mediators to perform free the mediation.
Okay. Sounds very promising.
Yes, hopefully in this way we can introduce mediation in practice. So we all know what is mediation, more or less, but we haven't seen it actually. We have like some thousands of mediators in Cyprus, but I'm not sure if we have any, at least commercial mediation completed. Commercial, not of any other nature. So this is what we are trying to implement, is just to introduce the procedure, and I believe if everything goes well, and we don't mind in succeeding in resolving the case per se, the case will be waiting for its turn to be tried in any way. I mean, whatever you get out of it, it will be a positive outcome in promoting mediation.
Okay. Now I would like to open the floor to the audience if you have any questions. Okay, so I will then invite. Sorry. Yes. This microphone was. Question or a comment?
Μπορώ να το κάνω στα ελληνικά. Υπάρχει μετάφραση, φαντάζομαι.
Ναι.
Ναι, γιατί είναι
όχι,
πολύ...
Μισό λεπτό.
Ναι.
Υπάρχει? Όχι.
Όχι, so in English. A contribution, a comment for Greek system and mediation. I think that in family disputes in Greece, we have a broad implementation of mediation, I could say. And in all disputes, even not family disputes, that have a personal point, I mean a loan between two brothers, or something that has a personal point, actually. We can see that in Greece mediation is broadly used. Another point is that it created many problems for real adjudicating on the merits of the case. We have many procedural obstacles due to mediation law, and sometimes it is not so well implemented from the judiciary, and we have some problems on this in Greece.
Okay.
Χρησιμοποιείται δηλαδή ουσιαστικά δημιουργώντας δικονομικά προσκόμματα στην πραγματικότητα.
Okay. Eleni, any final comments?
Yes, there are two opinions in case law about this provision of the law of 2019. So there are judges that are in favor of they apply the provision that says the mediation is mandatory in order to proceed to a hearing. And there are some other judges that say they are more flexible in this, and they review the claim on the merits, and they don't stick to this procedural law about the mandatory. Yes. And but in the first years of the provision of the law 2019, that was a big problem, because lawyers didn't know what to do, and there were the judges that insisted on these procedural obstacles, I could say.
Any other final comments?
I have a question actually for everyone.
For everyone on the panel? Or?
From the panel and from the audience. So it seems to me that in Cyprus we're trying to introduce mandatory mediation, which I feel I need to clarify that what is mandatory is to get into the process, which it can then not be successful.
So it's coercion into mediation and not coercion.
Yes. So I think, so when we say mandatory mediation, I think we all feel that, oh, they go into mediation and they have to absolutely reach settlement, which they may walk away. The other development I think we should all have in mind is that we now have the Singapore Convention. Now, what gave arbitration teeth was the New York Convention, 1958, which allows for the recognition and enforcement not only of arbitral awards, but also the arbitration agreements. The Singapore Convention aims to do the same for international mediation settlements. So I think there needs to be a call for Cyprus to consider joining it. I haven't heard anything in the news. It may be that we are considering, but the UK has expressed their intention to join the Singapore Convention.
Well, maybe Theano can convey the message.
I think we should.
I cannot comment on that actually, because I'm not taking the no, not on this.
Let me make a final positive comment, though. Because
I have a question. So
sure, sorry.
I'm sorry.
Positive comment first, maybe.
Okay.
No, I will leave it for the end. I will leave it for the end.
Yeah. My question is why we're choosing to establish mandatory mediation in Cyprus through the law, which in essence transposes the EU directive, and we're not doing it through the CPR rules like they're doing in England and Wales, which would then allow us to test, pilot, and then come back. Whereas if we pass the law, when knowing how it works with Cyprus and how long it takes, I feel we may not be able to catch flaws or pitfalls that we may be able to do by utilizing the CPR rules. I think the CPR rules as a legal instrument has to be acknowledged for its, how an easy vehicle it is to drive for the system. So I think we need to be, yes, we reviewed them, they're new, but it doesn't mean we stopped there and then we look at them.
Well, if you're suggesting that the amendments to the CPR is a quick procedure,
it's not.
then I and Theano can assure you it is not.
It's not, but maybe we need to revisit how we are modernizing the civil procedure infrastructure. I think the CPR rules is the driver, not necessarily the law. I don't know what you think or what anybody else thinks. I think...
I agree totally with you that the CPR provisions are there and they could be, and that's how I started talking about, we have the new, I'm sorry, I took the floor without...
Nicola wanted to say something.
But I agree completely with you, and it's one of my observations towards the ministry about promoting this law. Sorry.
Three short points. One is, if we're really serious about tackling delays and that we want a culture of, pre-judgment, pre-court settlements, if we're really serious about that, the only solution is to make mandatory ADR to some point, at least to force the parties to engage in ADR. Otherwise, it will be just, academic discussions. The second point is that I'm really curious why, while in the Dyson report, the suggestion was for 3 tracks, exactly as in the English CPR, and eventually we only had 2, so we didn't have the small tracks. The small claims track. So I think it's time to introduce it. And I think Marco can confirm that. There is a correlation between domestic instruments. If they're similar to the EU-wide instruments, then litigants in the member states use it more often. So if we introduce a small claims track entirely similar to the EU-wide, the advantage will be twofold. And as Theano advocated in favor of the EU regulations to be included in the text of the new rules, only for cross-border disputes, I think this will be another step to make Cypriot litigants more familiar with the EU procedures.
Okay. The lady at the back wanted to say something. Hold on, let's get you the microphone first. Hello?
I'd like to say that people are more ready to access ADR forums because they are made aware of the legislation through internet and so on. So from personal experience, I know that a family member has approached the insurance forum for resolving an insurance issue. And after a year, the reply was, we cannot decide on the matter. So what happens and who regulates these forums? Who regulates how they conduct the procedures? Who regulates how they manage the time? What kind of decisions they make? And at the end of the day, what if they don't get a decision? The time lost, you know, there's a time limit in filing in courts. So they're undermining actually people's rights. I mean, okay, not everybody, but the experience that I had through this family member, I'm a lawyer, so I advised also on using this forum, and at the end of the day, what's the result? And it's not only to set up forums, you also, not you, I mean the legislation also has to provide what happens if there's a dead end. What happens if they're not okay with the way they conduct themselves? What happens with corruption? Because the courts are accountable, but when you ask people to address their claims to other people, laymen, who may have some kind of expertise, then okay, they have to abide by certain standards as well. So the legislation has to make if you're going to ask people to go to these forums, then you have to give them some safeguards.
Okay, so there's a concern about the quality and the safeguards. We all share the concern. I'm not sure if I agree if it is something to be regulated by the law, but we all share the concerns. So we need to find ways out of it. Anyway, I wanted to end this with a positive note. It's almost an anecdote because some time ago I popped into a paper which referred to PECA. PECA was the political organization during the struggle against the British. And it was a call by PECA for Cypriots not to take part in court proceedings as a passive opposition to the British colonial rule. So I called, of course, Professor Emilianidis, very excited about it, and I was so disappointed because he said, I'm already writing a paper on that. So a few weeks ago, he gave a lecture on this topic, and he's going to publish a paper on it. So I'm probably giving you some information which I shouldn't, but he's not here, so I can't share. What struck me most was that it was effectively a call to mediation, because what PECA did was it set up committees in villages and municipalities which acted as mediators, and it was very successful. So the argument that Cypriot culture doesn't go well with ADR or mediation or settlement very, I mean, it, to my mind, is nonsense. That's not the case. It's not the case, and it's proven by facts. So I urge you to read that paper when Professor Emilianidis finally publishes it, just to see that in a very quick call, in very extraordinary circumstances, Cypriots were very well prepared to accept mediation and settlement through these procedures. So I hope that gives a positive note as to where ADR may go from here. And with not taking any more of your time, I would like to thank my fellow panelists and you for your patience.